Before this hearing even begins, we've got a classic post-separation financial showdown. An ex parte order was signed, meaning one side got relief without the other present, and now the court is being asked to undo it. The accusation? Key facts may have been left out. A boyfriend contributing financially, employment status not fully clarified, and a mortgage hanging in the balance. Was this a case of misleading the court, or just messy separation finances? And wait until you see how the judge handles the second case, where remarriage flips the entire legal landscape. Stay with this one, because the rules of support get tested in real time.
This is set for hearing today. Mr. Blumberg, you filed a motion. Your client is asking for relief from an ex parte order that was signed by the court, requiring him to pay certain household expenses and so forth at the beginning of the case. Anything you wanted to state by way of oral argument in support of your motion today?
Well, I would just again reiterate to the court what my motion and supporting brief suggests, that the court signed an order based on information that was not accurate. I don't know if there were intentional misrepresentations made, but the net effect of those is that you signed an ex parte order requiring my client to pay certain obligations, when the reality is that when the motion that was filed, it was asserted that she was not working and that she failed to indicate to the court that she had her boyfriend living there, a roommate who was contributing financially to the obligations. Those are certainly material facts that were either omitted carelessly or intentionally. The bottom line is that I think that had the facts been properly represented to you, you would not have signed such an order. So we're asking the court at this point to rescind that order. My client has been contributing financially, and he's prepared to continue to do so. But certainly, based on the facts that you were presented, I think that ex parte order was inappropriate.
Mr. Blumberg, are there any temporary orders regarding child support in place? Just looking through the file, you might know off the top.
No, there is not.
Okay. And how much is your client contributing monthly at this point?
Okay, he's paying between $150 and $200 a month.
Okay, pause right there. He's contributing between $150 and $200 a month, and there are no temporary child support orders in place. That detail matters, because what we're really talking about here is a mortgage obligation tied to both names, not formal support. The attorney's strategy is clear. Argue that the original ex parte order was granted based on incomplete financial disclosure. If she was working and had a contributing partner in the home, that changes the urgency calculation the judge made when signing that order. The question is, was that omission intentional or just poor communication during a chaotic separation? And in family court, perception can shape everything.
Okay. All right, Ms. Beeland, what's your side of this?
The reason why we decided for Chauncey to pay $600 worth of mortgage, because it is on his name too, along with mine. And during that time that I'm having a hard time understanding this. The reason why we put this, because I was working at a restaurant, barely making a minimum wage, trying to have fully intent of getting my job that is now, I work full-time at Kohl's, just so he could just help pay the mortgage. That's all I was asking. And my boyfriend, he is no longer in the home, but during that time, he was helping pay all the smaller bills, helping me out with that type of stuff. And up until he recently left, he was helping me pay all my small bills, and I was paying my mortgage and trying to keep on boat on that. And I have caught up completely on my mortgage so far. It's been hard, but I've been dealing. So I was just asking for help with that. That's all.
Now this is where it gets layered. She explains she was barely making minimum wage at the time, has since secured full-time employment, and says the boyfriend was helping with smaller bills, not the mortgage. That distinction is important. Helping with utilities isn't the same as sharing long-term financial responsibility for real property. And she's caught up on the mortgage, which tells the judge she's been making serious effort. So now the court is weighing fairness, not just technicalities. Should someone on the mortgage be obligated to contribute more than $150 to $200? Or is $600 excessive under the real circumstances? This is where judicial discretion takes center stage.
All right. Anything in response to that, Mr. Blumberg?
Judge, I don't know that we need to go into the facts why the boyfriend is no longer there. My understanding is he's been arrested and he probably has a no contact provision. But I don't guess that that's really relevant at this point. My client is willing to continue to pay some money to assist, and certainly the kids are with him half the time. So I just, I'm always reluctant when I see these ex parte orders, when facts are presented to the court, and you have no way of knowing whether they're accurate or truthful or not. And I understand it's always best to err on the side of caution, but I genuinely believe that had the facts been properly presented, I don't think you would have signed this order. He'll continue to pay those expenses that he's been paying.
Okay. And Mr. Blumberg, your client is on the mortgage as well, his name?
Yeah. Yes, it is.
All right, so presumably he's got just as much an interest in keeping that mortgage current as Mrs. Phelan does?
Yeah, he does, but he has the expense of another place. Again, when these parties separated, my understanding was that they had an understanding as to how the expenses were going to be shared. That wasn't reflected in any written document, unfortunately. But yes, you're right. He has a monetary interest in that property.
All right. Give me just 1 second. I just want to. All right. Is there an amount that we can put on the record here today that your client is willing to contribute per month?
Yeah, my client said he can pay $200 a month.
All right. Okay. So I think that's fair during the pendency here, given the circumstances. So Mr. Blumberg, the court is going to modify that order and have it reflect that your client is going to pay $200 per month.
And there it is. Modification granted. The judge reduces the obligation to $200 per month during the pendency of the case. Notice how balanced that ruling is. The court acknowledges both realities. He's on the mortgage and has an interest in protecting the property, but also recognizes he maintains a separate household. This isn't punishment, it's temporary stabilization. That's what pendente lite orders are meant to do, keep things afloat until a final resolution. Do you think $200 is fair given shared ownership, or should shared title mean shared responsibility regardless of separation? Drop your thoughts below.
Towards the household expenses. So if you can draft an order that will reflect that and submit that to the court, and we'll go forward from there. Ms. Phelan, do you have any questions about that?
No, I appreciate any of the help I can get. So I just appreciate it. Thank you.
Mr. Blumberg, anything further on this file today?
No, Judge, thank you.
Okay, thank you. All parties are free to disconnect at this time.
And just when you think we're done with financial disputes, we pivot straight into spousal support and remarriage. Now this is critical. Remarriage is often a legal trigger. In many jurisdictions, it automatically terminates spousal support unless the divorce judgment says otherwise. So when the judge asks whether she remarried at the end of 2024, this isn't small talk, it's the entire case. If that fact is undisputed, the legal consequences are almost mechanical. Watch how quickly this turns.
This is set for a motion today. Mr. Van Til, you filed a motion to cease spousal support, and your motion's based on the fact that Ms. Van Til remarried at the end of 2024. Is that correct?
Yes.
Okay. Ms. Van Til, is that correct?
Yes.
Okay. Are you contesting the discontinuation of the spousal support?
To an extent, I feel that I was
pretty generous back in 2021 when I let him off on over $12,000 in arrearages at the time. I'm willing to drop down to $500 a month for, let's say, another 3 years.
Okay, Mr. Van Til, what's your position on that?
No, I disagree.
Okay.
I
All
disagree.
right, well, you know, here's the thing. I reviewed the original judgment of divorce, and it does allow for the court to modify spousal support based on a change in circumstances. Ms. Van Til, and frankly, I'm surprised it doesn't contain the language that if you remarry, typically once a party remarries, I mean, that's a change in circumstances that warrants the cessation of payment of spousal support. And the whole idea of spousal support is that you don't have the assistance of your marital partner anymore to support you. And when you get remarried, that's no longer the case. So it really, to me, the only fact here that would be a potential issue is whether or not you were actually married or remarried, I should say. And it sounds like that's not a fact that's in dispute. So for that reason, the court finds that the spousal support should see.
That explanation from the bench is textbook family law. Spousal support exists because one spouse no longer has the financial backing of their marital partner. But once remarriage happens, that foundational premise changes. The judge even points out that most divorce judgments explicitly state this, though this one didn't. Still, remarriage qualifies as a substantial change in circumstances. And here's the procedural lesson. Even when you win, you must submit the written order. Until it's signed, the obligation technically continues. Legal victory means nothing without proper paperwork. That follow-through is everything.
And so, Mr. Van Til, you need to file something with the court that indicates that the court is granting your motion. You can use a form like you used to file your motion in this case, okay?
Okay.
But that's an important step for you to follow up on, because until I sign that order, I mean, that's what actually stops your obligation for spousal support. So it's important that you submit that as soon as possible to the clerk's office here in Gaylord.
Okay, so it's the form just like the one I sent for this hearing.
Yep, well, you can find the form in the same place. It's going to be just a blank order. And you're going to fill in there that the court is granting your motion and spousal support will stop as of February 3rd, okay?
Okay.
Ms. Van Til, did you have any questions about that?
No.
Okay. All right, thank you. That's all for this hearing today. Both parties are free to disconnect at this time.
Thank you.
Defendant is not full of money. That is the whole reason we're here. We need spousal support. The spousal support that was awarded previously was inequitable and unfair to defendant, and she is essentially barely getting by having to dip into whatever property award that she was given.
This hearing gave us two powerful reminders about family court. First, ex parte orders are granted cautiously, and they can be modified when fuller financial realities emerge. Transparency matters. Second, remarriage fundamentally alters the landscape of spousal support. Courts don't treat it emotionally, they treat it structurally. Support is tied to need and circumstance, not past generosity or prior arrears forgiveness. Once the legal condition changes, the obligation often ends. If you found this case as revealing as we did, make sure to hit that like button, share your perspective in the comments, especially on whether $200 was fair, and don't forget to subscribe for more real courtroom breakdowns and legal drama you won't see anywhere else.